I'm granting. I'm rescinding the sentence. I'm granting the JOA.
This corrupt cop lied on a citation, hoping that the judge would let it slide, but he had absolutely no clue how this honest judge would take him apart and make him a clown for everyone to see.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to null process that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point...
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
This action visibly angered the judge, and he would not stop here as he went on to grant more favors to the defendant.
This whole case was fishy, and I have no idea how they... You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
You don't agree with the state's decision on
I'm
the other
granting the
charge?
JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion to JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? No.
Thank you, Your Honor.
The case should have never been made. Never.
Thank you for letting us know that, Your Honor.
The judge not only reversed his decision, but acquitted the defendant on the spot, leaving the arresting officer and his attorney in dismay. Well, sometimes police officers do the unthinkable in courtrooms, costing their cities thousands of dollars. In a September 2012 hearing of an assault case, Judge Doris Bird laid out punishment for an assault like Anthony Waller when a police officer decided to take matters into his own hands.
Investigation for false imprisonment, assault in the third degree, assault as a class 2 felony, and a misdemeanor charge as well in possession of drug paraphernalia.
I'd like to object first. If I'm under investigation, I thought the investigation came first, then the rest came.
Hold on, man. Get on your feet. Don't turn on me. Get on your feet.
Waller was only talking to the judge when Deputy Brady Lovingier slammed him to the ground before taking him away. The suspect later claimed that he suffered broken teeth and head wounds. As a result, the deputy was suspended by the sheriff's office and ultimately resigned. On the other hand, Mr. Waller ended up getting $50,000 in damages from a federal jury. This officer lost his job for this. But what happened to this next bully in court will leave you all satisfied.
5 individuals claimed that this defendant taped them when they were not consenting to it, when they were not looking.
January 2023, Behar County Deputy Andrew Garcia was arrested for using his taser on cadets in training. Garcia was charged with 2 counts of official oppression, assault with bodily injury, and harassment. He pled guilty to the charges as Judge Boyd proceeded with the case.
You entered a plea to account for tampering with the government record. You entered a plea of guilty. The state waives counts 1, 2, 3, 5, 6, and 7. According to the plea bargaining agreement, punishment is to be assessed at 1 year in the state jail facility. The state recommends community supervision. They're opposing your application for deferred adjudication. Have both parties had a chance to review the PSI report, state?
Yes, Judge. We have.
Defense?
Yes, Your Honor. In fact, I've gone over my client and given him a chance to read it at his own pace.
It was Deputy Chavez.
No. Not in training, because you were not tasing people in training. I know that sometimes, and I don't know if it's still the case, I think it's not the case, they would tase officers in training so they would know this is the voltage of the taser, this is how it feels.
The state attorney explained what Deputy Garcia had actually done. The revelations will surely leave you in shock and dismay.
Yes, Judge. So this defendant took advantage of people who he was supposed to be supervising and training in the Bexar County Jail. He was the CERT deputy in charge of cadets and lockdown units with violent offenders, people with ag assaults, murder charges pending. At least 5 individuals claim that this defendant tased them when they were not consenting to it, when they were not looking, and that he did it in front of inmates, which, jeopardizes the security of the jail and also does not help with the retention issues that the jail is having as well. At least 2 of the victims left after that they were tased because they didn't want to be part of that work environment. Some of them were tased on the arms, legs, back, stomach. Multiple people said they did not want to be tased. He did it anyways. There's evidence that after he tased them and that the victims would ask him, "Why'd you do that?" He would look at them and smile. Some of the people consented to being tased. However, it was under a type of duress. For example, one of the victims went to him asking for clippers so that they could cut the inmate's hair in another unit. And he said, "I'll give them to you if you let me tase you."
It's bizarre to hear that a law enforcement officer was being a straight-up bully and was harassing his juniors who were there for training. However, the events keep on getting worse.
In the PSI, I noticed that he said that he had been tased before. There's evidence that was uncovered throughout the investigation that he would, when the victims would say, "Hey man, why'd you do that to me? Have you ever been tased?" He would respond back with, "No, and I'm not going to let anyone tase me." So I don't know which part of that is actually true. I just want to make it very clear that when these reports come out and when all this stuff is happening, they don't say Andrew Garcia was tasing people in the jail. They say a Bexar County Sheriff's deputy was tasing people. He's besmirched the badge of the Bexar County Sheriff's Office. This is supposed to be a controlled environment, and he added chaos to an already chaotic environment. By doing this in front of the inmates, it put not only him in jeopardy and the cadets, but also the other inmates. And it was his sole job in the jail to maintain the health and safety of the inmates who were there. When he was confronted about it, he put on a government record that he does not recall this ever happening. However, in the PSI, he says the reason he did it is because it was done to him. The old saying, if all your friends jump off of a bridge, are you going to do it too? And here it seems like he just went along with it and was tasing all these cadets.
The poor cadet who was multiple times spoke to investigators, or else this unlawful practice might have continued even longer.
The defendant is 6'10", 245 pounds, at least at the time when he was working there. One of the victims is 5'2" and 112 pounds. And he reported that he was held up against the wall physically, and that this defendant would not set him down, that he would put him into an arm bar in front of other inmates and tase him multiple times in front of other inmates. This was not a one-off time, Judge. If it was, I don't think the state would be having such an issue with the bird. It's the fact that we found out that this happened to 1, 2, 3, 4, 5, 6 individuals, and the one individual he didn't tase, he would harass. So when he would go to start doing his checks on the inmates, this defendant would point the red dot at him, come up behind him and clack the taser while the cadet was just trying to do his job. Therefore, the state thinks that this defendant should carry a conviction because of the egregiousness and because he has besmirched the badge of the Bexar County Sheriff's Office.
Defense.
It seemed the bully enjoyed harassing and attacking those innocent young cadets. Shortly after, his attorney had the floor, and the corrupt deputy tried his best to play the victim card.
What you're accused of by tasing and harassing these cadets is not a proper work environment or training environment for them?
100%.
Okay. Have you learned from this not to do something like that?
100%, yes.
Okay. Were you ever tased? Yes or no?
Yes, I was.
Okay. And is it part of training that everybody's going to get tased sooner or later? Normally a time when they get tased.
At a time and a place, yes.
Okay. And did you notice anything from the inmates reacting to your alleged misconduct?
I'm saying I do not recall tasing in front of inmates.
Okay. All right. So, and this is your first offense,
yes, sir.
Correct?
Okay. Excuse me. Norma.
This is a first-time offender. I do understand what I did was, wrong. I would not do it again. It's a mistake. I'm about to get married here in the next couple of weeks. I asked for, if you put it on deferred, I would greatly appreciate it. I have done my lesson, Your Honor. And I would never ever do anything like this again.
Okay.
Any questions?
Any questions from the state?
Just a few questions. So your attorney asked you, you know that that's not a proper work environment, stuff to do in the work environment, correct? But you understand this is more than just some type of workplace harassment, that was criminal conduct you were doing,
Yes,
where you were housing people who have allegedly committed crimes.
correct.
So in fact, you were committing crimes in the jail.
Correct.
No further questions, Judge.
Nothing else, Your Honor.
All right.
After the defense and state presented their arguments, Judge Boyd took charge and announced the sentence. But before that, she took this bully to the cleaners.
We are actually going to marriage license to pick up the proper documents, and then whenever I guess they have their scheduling, we'll pick a date, but as soon as possible.
All right. The state is asking for you to have a conviction. If this were counts 1, 2, 3, 5, 6, and 7, I would probably have no question about giving you a conviction. But however, you do need to be punished. And punished is not just permanent surrender of your TCO license. So I'm going to give you a choice. I will give you 4 years deferred adjudication. With that, you're going into custody to the Bexar County Jail for 30 days. That's your punishment. Or I will give you a conviction. Which do you choose?
And the conviction will, are you just giving regular probation? Is that what you're saying,
Yes.
Your Honor?
Deputy Garcia was a lying coward. The only reason he didn't want to go to the same jail he worked at was because he couldn't face the cadets he was bullying for fun.
Only one that works with my family. My wife is focused on her degree, and it's. I don't want to be in jail, Your Honor.
Well, the people you tased, they just wanted to, I'm assuming they were there to support their families as well. So why were you tasing people? And I don't want to hear, because how old are you?
24.
24. I don't want to hear this is like college and people are hazing people. I never understood why people who had been hazed decide to haze other people. So why were you tasing people at the jail who are just there? And I know those cadets are young because I've seen some of them. They're 18. Some of them look as though they're 12. So why were you tasing cadets?
Your Honor, doesn't make it right. It's a thing that's going around.
Oh, you're saying there are other cadets there are other people at the name.
Deputy Garcia tried to cover up by claiming it was a long-standing practice. The judge cut him off and went over to humble him for the next few minutes, leaving him speechless.
Who are tasing people at the jail.
Off the top of my head, Your Honor, it's been a while. I don't.
No, I'm thinking, who tased you? Give me a name. I'm sure the state would like to know these names. So who are the names of the people who were tasing you?
Your Honor, I do not remember.
Of course, you always remember the first person who tased you.
The first person who tased me was in proper training.
Oh, what's their name?
That was.
All of the complainants in this case remember you as tasing them. That's why you're here. So who tased you?
In proper training, it was Deputy Chavez.
No. Not in training, because you were not tasing people in training. I know that sometimes, and I don't know if it's still the case, I think it's not the case, they would tase officers in training so they would know this is the voltage of the taser, this is how it feels. Much like in the military, when they release the gas, so you'll know how to wear your mask properly. No, I'm talking about who tased you improperly, because that's why we're here. You're saying people hazed you, so you're just hazing people. So who are these people who tased you when you were not in training?
Your Honor, I do not remember names.
All right, so who else is tasing people at the jail?
Garcia tried to dodge the question, but didn't realize he was up against a brilliant judge who wouldn't let him off so easily.
Because that's what you're telling people. You're telling me, you're telling the states, you're telling the attorney that there's tasing happening at the jail. I'm sure those cadets don't want to be tased if it's not in training. So who are these other people who are tasing cadets? We want to know. So tell me who they are. Do you need to sit in the box while you think of the names of the people?
Mr. Randall.
Any reason why are you not intentionally not remembering names, correct?
No, I cannot remember.
Oh, I mean, if you want to sit in the box and think about the names, because you can't just throw around people are being tased at the jail by other people and then that's it. Who are these people who are tasing people? There's nothing worse. Well, there may be other things that are worse than people who say, well, I heard. But you're not saying I heard.
Yes, ma'am.
You're saying, oh, now you're changing it to I heard?
I haven't seen someone get tased. I've heard of stories of people getting tased, and I just ran with that.
Oh, so he's never seen anybody tased. So now he's not just continuing the hazing that happened to him. He was just tasing people. Your unborn child, is this going to be a girl or a boy?
He's born 4 months old. He's a boy, yes, ma'am.
The deputy continued making a joke of himself, left with no answers. The pathetic bully never considered his actions wrong, and the judge kept pressing on his vague excuses.
He's born 4 months old. He's a boy, yes, ma'am.
4 months old. So what if he decides to be a cadet at the jail and somebody like you, who's 6'10", however much you weigh, is tasing him?
I would be unhappy with that.
Mm-hmm. How unhappy would you be?
Very unhappy. Very unhappy.
And how would you think the work environment would be for your son when they're constantly worried about some guy who's bigger than them tase them?
As a parent, I would not approve of that work environment, Your Honor.
Mm-hmm. That's what you did. Some people would call it being a bully, but that's what you did.
Yes, ma'am.
So you deserve a conviction, and I'm going to give you a conviction. Is there anything else from either party? In the state jail facility, suspended and probated for 4 years. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting. Oh, and if I haven't said it before, I'm finding you guilty. There's to be regular reporting by Zoom or in person. There's to be regular UAs. There's to be the permanent surrender of your TCOL license. And I know sometimes people will give up their TCOL license, but then they go to another state and they're allowed to become officers again. So while you're on this probation, there's to be no employment as a security officer.
In my opinion, the deputy was lucky not to get a jail sentence. His punishment felt like a slap on the wrist. But the judge made sure to humble him one last time.
Court is not waiving any of those hours, and I'm going to require parenting classes. Probation, is there anything else? Is there anything else you need from the court to be successful?
Want the judge give you anything, help you at all? This is your time to ask.
Sir, is there anything else you need from the court to be successful on this probation?
No.
All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it? All right, we can go off the record. I understand why you don't want to do your time at the Bexar County Jail. And you know what? I know it has to do with people in the box and security for you at the Bexar County Jail. So that heavy beating of your heart, that's the heavy beating that all of those cadets had whenever you were on shift. And you need to remember that. Do you understand?
Sure.
All right, good luck to you. Yes.
I apologize. You want field visits?
Yes, field visits once a month for 3 months. All right, just have a seat. They'll go over conditions with you. With your attorney, did you understand it, and did you sign it? All right, we can go off the record. I understand why you don't want to do your time at the Bexar County Jail. And you know what? I know it has to do with people in the box and security for you at the Bexar County Jail. So that heavy beating of your heart, that's the heavy beating that all of those cadets had whenever you were on shift. And you need to remember that. Do you understand?
Sure.
All right, good luck to you. Yes.
I apologize. You want field visits?
Yes.
Garcia was immediately fired from the Bexar County Sheriff's Office. And although he wasn't arrested, he will never get to be a law enforcement officer again, thanks to Judge Boyd. Well, this isn't the last time a judge destroyed an officer in court, as this case will leave you stunned.
At least give me the satisfaction of knowing that you're out there beating up nigga. LOL. How humiliating and degrading. Be a positive example to Officer Zelensky.
On January 28, 2015, Inkster police officer William Mendez and his partner John pulled over a black man for a traffic violation. What followed will shock you as Judge Vonda Evans details the incident during the trial.
I'm going to start out with Mr. Dent. The victim involved in this tragedy is a 58-year-old black man who was driving his Cadillac in Inkster, a suburb of Detroit. On the evening of January 28, 2015, where his life changed forever, he was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zelensky. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and struck 16 times in the head by the defendant. In his attempt to arrest him, he was thrown onto a window shield of a patrol car, bleeding profusely from a head injury. The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten and cuffed.
This horrible beating had left Dent's face and shirt drenched in blood, but the officer's reaction to this was even worse.
The video in the car shows the police officers fist bumping as a celebratory act of bravery by the defendant and his cohorts. But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head. In disbelief of what had occurred to him. If his conduct was indicative of what he was thinking, I would have thought this: what crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers looking at. As police officer John Zelensky, auxiliary police officer, testified in court too, in his response to a text, was quoted as saying, "At least give me the satisfaction of knowing that you're out there beating up right now. LOL. How humiliating and degrading that must have been."
After his arrest, the officers kept on humiliating, cleaned his blood off their uniforms with disinfectant. Dent was also charged with resisting arrest and drug. The judge was devastated by the events and delivered a powerful, heartfelt lecture.
He was left in a cell for a number of hours before getting medical treatment. But after hearing the defendant and his fellow officers joke about his injuries as they were wiping blood off their uniforms with disinfectant. 2015. Please be quiet in my courtroom. How does this happen? I'm gonna tell you how it happened. Some years ago, 19 to be, well, 25 to be exact, I remember coming into this building with such enthusiasm, so excited. And I remember a lawyer telling me that nobody leaves out of this building like they came in. I didn't understand what that meant. You go to social events, you tell people what you do for a living, and after they say, what kind of cases do you hear? And as a judge, prosecution, defense, does criminal defense, a police officer, after a while they said, we don't want to know anymore. That's the job in the criminal justice system.
Racist Officer William could only sit and listen as the judge spoke. How fitting that he was being humbled by an African-American woman.
These pressures and expectations force officers who have a pure desire to purely serve the community as an occupation to conform to this group mentally or face being ostracized and labeled as an outcast among that group. These methods of indoctrination are passed along to new police recruits in the academy by stressing the importance of obedience to authority through a structure of shame and honor. It teaches them to conform and obey to the prevailing standards of the police culture. Field training, the recruit gets a reality check of what it's like to be out in the city. I was out at a mall yesterday. I asked a woman a question. I said, you don't have to answer. How much do you get paid an hour? She said, $15 with benefits. Well, guess what? That's more than what Inkster gets. They don't get benefits. The equipment, the police cars are old. We went out to the scene. Early in the morning, there were people who were using drugs. They just kind of came out. And the only thing I could imagine was the only thing that is separating these people from drugs are the police officers that appeared in my court.
Judge Vonda not only blasted the officer in question, but also questioned the overall system that produces such cops. On the other hand, all charges against Dent were dropped, and he settled with the city for $1.4 million.
According to Law Enforcement Today, a publication, police officers had the highest rate of alcoholism, divorce, drug abuse, suicide. Their life expectancy is 10 years less than the average American. Police are human beings too. They feel despair and they have ups and downs. Their job is made worse because they see on a daily basis, more than any other occupation, the worst behavior that people can inflict on one another. They go to work every day with the knowledge that some of the people that they are sworn to protect and serve want to kill them. But how do we as a community expect superior services from police officers who are making security guard salaries to receiving little compensation and struggling just to pay health care? We would rather save a few dollars to balance a budget than pay millions of dollars to reverse a tragedy that we could have prevented. I know that Mr. Dent would give back every dime of his $1 million settlement to go back to where he was in his life before January 28th. I wonder what would one half of that $1.4 million settlement awarded to Mr. Dent have done for the Inkster Police Department. Training officers that wanted to serve and not hiring officers that didn't belong. It's my belief that when we begin to value and properly compensate and train those that want to serve, then and only then will we as a community receive the type of services that we expect and demand from the defenders of our community, the police. It's amazing how poor cities like Flint can find millions of dollars to attempt to reverse a situation that $100 a day could and would have prevented.
Next, watch as another officer comes face to face with a no-nonsense judge who wasn't about to let corruption slide, and it all led to his ultimate undoing.
Date of birth, 12/18/70. And that will make you how old? 52, sir. And the last 4 digits, your social security number? Mr. Noel, Special Prosecutor Purtle has charged you with 15 counts of criminal conduct. And I'll go through it. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018 and August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally, through a pattern of racketeering activity, acquire or maintain, either directly or indirectly, an interest in or control of property or enterprise contrary to the form of the statute in such case made and provided. Count 2, theft as a level 5 felony. You then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A.
Numerous charges were also brought against Jamie Knoll's daughter, Casey, and his wife, Misty. It is truly remarkable to see how the sheriff was able to engage in such corruption and yet maintained his position in the agency for such a long time.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation, that being you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff and public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff. Assigned walkery duties on your personal property, rental properties, father-in-law's property, pole barn, and the property of the Utica Fire Department. Count 11 and count 15. Official misconduct is a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties.
While this officer's actions were shocking, what the next cop did brought outright disgrace to his entire department, and he was sentenced to life.
Count 28, the first degree. Defendant is guilty of the crime of rape first degree, and punishment is set at 30 years.
This is Officer Daniel Holtzclaw, who was sentenced to 263 years in prison. Today we'll uncover the chilling story of his crimes and how he was ultimately exposed and brought to justice in the courtroom. Make sure to watch until the end, as the disturbing details will leave you stunned.
Do you recall putting your penis in her mouth?
I don't. I didn't see her
breasts.
I didn't see her breasts.
It all began on the night of June 18, 2024, when Holtzclaw was heading home after completing his shift. That is when he conducted a traffic stop of a 57-year-old woman, Janie Ligon. During the stop, the officer made her lift her skirt and pull her pants down before forcing her to perform oral on him. The very next morning, Janie headed over to the Oklahoma Police Department, and as Holtzclaw came for his shift the next morning, he was greeted by detectives Kim Davis and Rocky Gregory for interrogation.
Tell me about that stop.
I was going westbound on Northeast 50th, probably a block just east of Lincoln. I see a red Grand Prix or Grand Am in my right lane, in the outside lane. I'm in the inside lane. The car swerves, and so at the time I'm thinking, okay, it's probably a drunk person, or maybe got excited because they saw a cop. Made contact. It was a black female. Asked for license and insurance. Stated that she didn't have insurance. Gave me an ID.
Do you make traffic stops normally after work?
I don't, but in that case, I saw her swerve and whatnot, so
I mean, me, I don't.
Felt.
Off work.
I know. I mean, people, cops say that as have a, you know.
At the time of the stop, Holtzclaw had illegally turned off his GPS and patrol car computer, a clear violation of protocol. Detective Kim Davis quickly realized the seriousness of the situation and began investigating the alarming allegation.
Okay, so you got her out of the car?
Yes.
Okay. And put her in the back of your car?
Yes.
Okay. Any problems there?
No, she was cooperative. Didn't give me any problems or whatnot.
Did you run her on your MDT?
No, I didn't. All my stuff as far as that, because I didn't call it in and say I was at a traffic stop. My computer was off and everything as well.
Did you shut it off?
I just shut it off,
work?
yeah.
When you put her in your car, did you pat search her?
When I came around, I was like, lift up your shirt. Is there anything on you? Anything as far as your waistband or anything like that? She said no. And then I put her in the vehicle and went from there. Asked her everything.
Did your hands go on her at all?
I backhanded her on as far as the side.
Where on her body? Tell me. You backhanded?
Her waist, and the back portion. I didn't touch her butt or anything, but the back portion of the waist. And then she lifted it up like right here, and there's nothing.
Did she lift it up like this?
No.
Okay. So she never, like, went, whoo, nothing, exposed her breasts or anything like that?
She asked me if I was like, no, it's okay.
The predator officer appeared quite calm and composed, having no clue that his dirty secrets were about to be exposed.
Saying it was the hip, the side, not the section.
What about right here?
No.
You didn't?
No, I didn't.
They can tuck a gun
That's
right here.
why I asked to lift it up.
Oh, so she just kind of showed you her belly?
Right.
Okay. Well, was there anything, an accidental touch, anything?
If she thought it when I passed searched her, but it was nothing as far as I felt like I would do anything as far as anything like that. And for my safety, I just checked to see the weapons or anything. And to make clear, I didn't touch her butt, by the waist side and whatnot. If you would like me to do it for you to show you.
No, and I'm fine with it, and you have every right to do that. She's saying that you made her lift up her shirt, and when she lifted up her shirt, she exposed her breasts.
No.
You'll be shocked to learn that this wasn't the first time Officer Daniel Holtzclaw had abused his authority to intimidate and assault women. A multitude of black women soon came forward with similar allegations, exposing the true extent of this predator's crime.
She said, she said she was doing this. When you said, is there anything inside your bra? And she was, well, no, I don't have anything like that. Did she do that?
Yeah, she did, but I didn't look or anything like that.
Right.
And then she was like, do you want me to show you? I was like, no.
She said when she said, do you want me to show you? You said, yeah, and she went,
woo. No, I didn't.
But could she have been, woo, flashing you? And now you don't want to tell me because you're afraid you're going to get in trouble?
No, when I told her no, I said no.
Then she didn't go, yeah,
No.
you know, because sometimes drunk girls are
having a good time.
Yeah, but I'm asking you if she flashed you anyways.
I didn't see her. I didn't see her
no
breasts. I didn't see her breasts.
Okay. What about pants?
Nothing in her pants as far as I concerned. She was wearing tight jeans. So
She said she pulled them down.
I didn't see it.
You didn't see her pulling down?
I didn't see her pulling down pants. Did not see
You did not see her
breasts.
boobies.
No, I did not see her breasts.
So she's saying you shined your light on her.
I did not see her breasts.
Where do you keep your flashlight?
The left side right here. Right.
Detective Kim didn't hold on to the questions and laid out the allegations made by Janie. Shortly after, the other detective collected a swab to obtain Holtzclaw's DNA, as the woman had already submitted to a sexual assault exam.
Maybe a little bit over 5 minutes. Maybe like 5 minutes if.
So you're with her for 10 minutes. Did she say
Nervous.
why she was crying?
Says police officer and whatnot, and I'm just nervous because I got stopped by a police officer. So I'm like, calm down, everything's fine. And then, so I think maybe with the fact that she had no SDL, maybe she was nervous as well too. And then so.
Ralph, what time is it on your watch? I turned my phone off. So.
I've got 4:50. Sorry, 4:47. What I've got. So do you usually do traffic stops on going home, or what was?
I don't. Like I said before, I really, rarely don't. I usually try to get home because I'm tired of them and shit.
Well, and are you a big DUI worker?
When I first started coming out, I did. But not really at the end now, to be honest with you.
I usually, if I see somebody swarming, I'm the other way.
And that's what a lot of officers do too. So.
Well, Daniel, this is kind of one of the things that we kind of bring you in here to see how truthful you are.
Right.
Now you need to kind of think of a few different things here.
Okay.
Okay. We pulled up a lot of video around that area after these allegations.
Okay.
Okay. She also had a SANE exam, which you know what that consists of.
Right.
There's a reason why we wanted your buckles. So if we go off the video and watch that, you're still going to stick with your story.
Yes, sir. As far as that,
Do you recall putting this in her mouth?
I don't.
Would you recall that if you did it?
If I did it, yeah.
The officers had also gathered some CCTV footage of the incident, and although nothing was clear, it showed that Holtzclaw's car had been there for over 25 minutes, which raised several red flags.
We knew you were on that stop.
Right.
We knew you were there.
Mm-hmm.
And we can watch a whole lot of actions being performed while you were there.
Mm-hmm.
Okay? And that's why she was trying to give you every out on the whole thing.
Right.
But any reason why your penis would be out?
No.
But if we say we didn't do it, we didn't do it, we didn't do it, and then the DNA comes back and says he did it, then we have a huge problem.
Right.
Okay. On the video, are we going to see her boobies?
Shouldn't see her boobies. See her boobies.
Okay. Are we going to see her pull her pants down?
I didn't see her pull her pants down.
Okay. Are we going to see your penis out?
Nope.
Are we going to see your penis go in her mouth?
No.
Are we going to get any DNA to that?
No.
Shortly after, Detective Gregory dropped another bomb on Holtzclaw. Just a month ago, 43-year-old Terry Morris told the cops the same officer had found a crack pipe in her car and had threatened her with jail. He then asked her to expose herself and give him oral sex.
Probably not necessarily going to remember the name, but her name is Terry Morris. Okay, black female. Supposedly you promised her a ride to the city rescue mission. This ring a bell?
No.
She thought you ran her for warrants. The clicking. Drove her around.
Mm-hmm. No. Name doesn't. I don't recall a name like that.
Okay, but she's claiming the same thing. The exact same thing. And here again, for whatever reason, things are pointing at you again. Traffic stop, not logged in, all that stuff. Okay. How about any stops of a person just walking, even just downtown? Anywhere downtown?
No. I don't, in Spring Lake, I don't go downtown. Besides if I go to Classen, not Classen, but Western and Maine to Valero's.
Or the jail.
Or jail.
Or headquarters, property.
Right.
And you just don't remember doing any of those type of stops?
No.
Not in the last month or so?
No.
Do you run everybody that you come in contact with?
Majority of the time.
But you didn't run old girl this morning?
The
50th in Lincoln?
No, I didn't. I didn't run her.
The other girl that he's talking about is kind of making the same allegations, and that's weird.
Yeah, that
doesn't look good. I mean
that's
it doesn't
weird.
look. Yeah, it doesn't look good. So, no, I don't.
Holtzclaw denied any connection to Terry, but a pattern was emerging, targeting black, poor women with legal troubles, and the list was growing.
What to think? Would you take a polygraph?
Yeah, if you want to take a polygraph.
I mean, I'm trying to think of a solution. Do you know how slow DNA is?
I don't. I do not.
Slow.
When you went home, was anybody home?
My girlfriend was home.
Do you live with her?
Huh? No, she doesn't. She just stayed.
Did you get laid?
Messed around, yeah.
What's messed around?
I guess.
We were all adults.
We almost had sex, and she was tired.
What'd you do?
So my penis went around her vagina, and then maybe went a little bit in, and then she pushed me off and said, "No, we don't want to. I'm tired." I was like, "Okay."
That's kind of mean to let it get that far and then stop.
So
that's when you got home?
That's when I got home.
The detectives then started asking the officer some personal questions, which would eventually help them in the long run.
How often do you have?
About once a day, if that.
You guys have sex once a day?
Yeah.
How old are you?
27.
Well, yeah.
How much you jerk?
Maybe once a day.
So you sex once a day and masturbate once a day?
Yeah.
What'd you do when you got shot down at home today? Usually you got to relieve that.
Right.
I know.
That was before work. That happened before work.
You masturbated before?
Yeah.
The detective returned to the topic knowing that she wouldn't be leaving soon. Despite the hour-long interrogation, Officer Holtzclaw remained calm and composed, showing no signs of desperation or anger.
If she goes like this, well, she's gonna be looking right at you.
Okay. But it was just talking.
Let me ask you this, did you ever get a hard when you were talking to her? Because she could have.
I don't think
these
I got.
pants don't fit the greatest,
Right.
and if you get a, I'm gonna be able to tell you got a.
Right. And I'm pretty positive I didn't get a hard.
Didn't get a hard on when you talked to her. Did your pants come unzipped, unbuttoned, anything while you were standing right there?
No.
CSI is processing your car right now.
Right.
And when we stepped out, they found some pubic hairs right in here. Could they be yours?
No, that's not. I didn't pull my penis out. I didn't do anything right there.
Did she?
No.
But do you think that could be?
No, it's not. No. Nothing of mine.
Your pubes couldn't be
No.
right there?
No.
There was now shocking evidence gathering against the officer, and by the end of this week, he would be facing rape accusations from 8 different women, including a 17-year-old minor.
You sure she just didn't flash you?
I can't. She did not. I want to say I can't recall, but I'm pretty positive she didn't flash me. She went like this, but nothing as far as I'm going like crazy looking.
Lifting the shirt.
No.
How far did she lift it?
When she lifted it up first, when I patted her down, she was like right here to her stomach line.
Did you see her belly?
Maybe some fat rolls or something. I don't know, but nothing.
Right, but I mean, could you see skin?
Yeah, I saw skin. Yeah. Yeah.
You like older women?
I don't.
How old's your girlfriend?
She's 25.
Okay.
What's the oldest lady you've slept with?
Maybe 29.
You ever slept with a black woman?
I have. In high school, I have.
Okay.
Why would she make? Because when a woman says something like this, and they go through a sane exam, and they get, you didn't give her a ticket, so she's not getting out of a ticket. You didn't arrest her, because we get those when they go to jail. I've been raped. Work those stupid things because they think they're going to get out of jail.
Right.
The detectives had no reason to doubt the woman. She had nothing to gain and wasn't even ticketed during the traffic stop. The odds were stacked against Holtzclaw, and he had little to defend himself.
Anyway, those pubes are going to be yours.
No, they're not. Please. Go.
I know. We're going to test it. It just takes. Anyway, your skin cells are going to be anywhere on her mouth.
No.
Skin cells from your fingers.
No.
Did you touch her body anywhere other than with the back of your hand, pat searching her?
I just passed her, and that was about it. Didn't touch her face or anything. Right.
Because if the tests come back, you ain't coming back in here.
Because we have a woman that says about, basically being sexually assaulted.
Right.
Okay? And we're calling it by force and all that. Big difference between that and a hookup.
Right. Nothing else.
But when she was standing, did she try to pull her pants down?
No. No.
Did she do, you said she kind of did like this. Did she ever do anything down here?
No.
You said you take the lie detector test.
Right.
Do you have any extra job? Is there a time when you can't take a lie detector test?
No.
You're saying about 15-minute traffic stop. How long do you usually take on traffic stop, just on average?
Maybe 20 minutes.
It was shocking how Holtzclaw stayed calm, despite being asked questions that would anger most officers. He kept denying everything, hoping his badge would protect him again.
20 minutes. Now that's going to be some 800 time, right?
800, searching the car in detail, all of that.
Okay, so doing all of that, all the running, waiting in line, and even on a search. Now, the question I have is we got a lapse of time here, so I'm kind of get a better handle on where the time went. You're talking about 15 minutes, no 800, no running on the computer, you shut it down. And you said it was just a quick little search of the car. Where's the rest of that time?
Just talking to her.
About what?
Just see where you go and trying to get her to confess, are you drunk or not? Like, are you been drinking? Because I could smell it when I was in the car, but I can't really get it.
What if she said, yes, I'm drunk?
I didn't hear a lot of drunk questions, you know, like how much
Have
did
you been drinking? Mainly it's just have you been drinking, trying to get her confessed, see anything inside that juice. But,
Okay, right there, those questions maybe took 40 seconds. 15 minutes?
And you said 5 at the car. So then we got 10 of a lot of questions.
Right.
Okay. I mean, you tell me I wasn't there. I mean, obviously I don't have any audio.
And that's what I'm saying. Roughly on a traffic stop take about 20 minutes.
Time was a key piece of evidence. Holtzclaw didn't issue a ticket or run her name, but spent 15 minutes talking to her. Something was clearly off, and the detectives were closing in.
How could you take 15 minutes on that?
Just talking. I must have been talking. So.
I can't see her wanting to talk if she's crying and asking if you're gonna and all this. I don't see her being real forthcoming with conversation.
Whether my questions or whatnot, that's it.
I mean, you don't seem, I mean, I don't know how you were out there, but just kind of talking with you. I mean, you seem real laid back and everything like that. I've never got the impression of just kind of an angry type cop. We know some.
So you don't think 15 minutes was too long on that traffic stop?
No,
And nothing sexual on during that 15 minutes?
Nothing sexual.
Detective Kim left the room, leaving Holtzclaw alone for over 10 minutes. When she returned, she had proof of the first of many lies that he had told.
I just talked to Carrie.
Okay.
She said she was asleep when you got home and you did not try to have sex, and you did not have sex.
Did try to have sex.
She said you didn't. And I asked her, could you have been asleep? And you had kind of, no, and she said no. You did not try to have sex.
As much as I don't want to involve her, I tried to have sex with her and she was asleep. Carrie goes to sleep pretty early, about 9, 10 at the late.
Okay, but she would know if you tried. I'm a woman.
I know.
And my husband comes home in the middle of the night and I'm like, are you kidding me? I've been asleep. You said you twirled around her vagina.
I did.
And you put it in a little bit and then she said, I'm tired. No.
I did.
She would remember that to tell me.
Shoot, maybe.
She said you did not try to have sex.
The officer's actions really weakened his case, as he was now caught lying about the very first statement he made about that night.
I don't know what to say. I mean, because it just looks like I just caught you in a lie, and now I don't know what to believe.
I'm telling you.
I don't know what to believe.
Okay.
Because you tell me this, I go to verify it. She tells me the opposite, and now I'm wondering what you're telling the truth about.
Maybe because she doesn't know what the heck's going on.
No, she doesn't. I didn't tell her.
And I'm glad, but detectives calling her, any other officer asking her a question like that.
I know.
She made me scared. I'm telling you, I tried to have sex with Carrie, my girlfriend.
She is going to remember your ween twirling around her hoo-ha. You remember that. I'm sorry, I don't care how much of a sleeper you are. You remember because it pisses you off in the middle of the night and you go, are you serious? Don't bother me with that.
The interrogation ended with Holtzclaw being placed on administrative leave and ordered to surrender his uniform, badge, and gun. His uniform was immediately sent for DNA testing, a crucial step in the investigation.
Looks like you're gonna need to, unless you want to keep the shirt on. I don't know. I don't know if this shirt's gonna be big enough for you. You're a big old boy. Why don't you go ahead and get dressed then?
I need to tell you what's going on. It's crazy. I said when I'm basically on my way home, and I'd like to talk to you. What's going on? It's crazy.
Shortly after this, Detective Kim tracked down 6 more women who made the same claims against Holtzclaw. One of them was identified as 17-year-old Adara Gardner, who claimed that the officer assaulted her on her mother's porch. Shockingly, her DNA was found on the opening of the zip of the officer's pants, which were taken in for investigation. This almost sealed the deal, as he was ultimately facing 36 charges, including battery, assault, oral and stalking.
One, sexual battery. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment at 8 years. Count 2, procuring lewd exhibition. Not guilty of the crime of procuring exhibition. Defendant is not guilty of the crime of sexual battery. Count 8, defendant is guilty of the crime of forcible oral assault and punishment is set at 20 years. Count 9, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree.
Holtzclaw pleaded not guilty, claiming the women were motivated by monetary gain. However, on December 10, 2015, after a lengthy trial, the jury delivered their verdict. A jury of 12 white people were selected, who found Holtzclaw guilty on 18 charges. The officer kept weeping throughout the conviction as if he hadn't done anything wrong.
Count 16, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy. Punishment is set at 16 years. Count 17, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 18, procuring exhibition. Defendant is not guilty of the crime of procuring exhibition. Count 28, rape degree. Defendant is guilty of the crime of rape first degree and punishment is set at 30 years. Count 29, rape first degree. Defendant is guilty of the crime of rape in the first degree and punishment is set at 30 years. Count 30, battery. Defendant is guilty of the crime of battery and punishment is set at 8 years. Count 31, in the second degree by instrumentation. Defendant is guilty of the crime of rape in the second degree and punishment is set at 12 years.
Holtzclaw was fired from the police department, with the chief of police calling it the worst abuse of power in his 36-year career. Leaving the courtroom in tears, Holtzclaw repeatedly said, "I didn't do this."
Mr. Holtzclaw, this jury finds you guilty of the various counts. You will be remanded to the custody of the Oklahoma County Sheriff for formal sentencing set January 21st, 2016 at 10 o'clock a.m.
Your Honor, I'd ask to hold the jury.
All right, you have a seat.
Moving on, this next judge had no tolerance for the officer's conduct and wasted no time tearing him apart.
Justified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
Officer Eric DeValcanera was found guilty in the death of 26-year-old Cameron Lamb. Judge Dale Youngs announced his sentence, but had some important words for him before doing so.
And the parties have a right to expect that no matter what I hear, I will only consider factors that are appropriate and that I will disregard those that are inappropriate. And that is what I've done here. And as a result, I've concluded as follows. There are a number of facts in this case that are both and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead. And Eric DeValcanera killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel. Cameron Lamb's death leaves an irreparable and unfillable void in the lives of his family and his friends, and also in our community. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk.
The judge narrates the events that unfolded, and you'd be shocked to see the officer's disregard for citizens.
For those events tragically concluded with the actions of Troy Schwam and the defendant. Pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a, "Hey Troy, wait." At any point, Sergeant Schwam and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence, in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage.
Cameron Lamb was violent by the racially motivated officer. The 26-year-old was calmly sitting in his pickup truck when this pig shot him.
Then Sergeant Schwam and Eric DeValconaire arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offense as described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house. Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction, I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things.
After siding with Cameron the whole time and acknowledging that the officer slapped him, the judge eventually started to develop a soft corner for the officer.
Eric DeValconaire is not Derek Chauvin, George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him.
Ultimately, Judge Dale announced the sentence, which felt like a slap on the wrist for this corrupt cop.
It did on December 3rd of 2019. All of which, however, leads the court back to where it began an evaluation of the impact of the defendant's crime on Cameron Lamb and his family. Cameron Lamb is Eric DeValcanaire, and the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
Not from the state. No, sir.
Eric DeValcanaire, on count 1, the Class E felony of involuntary manslaughter in the second degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
6 years in prison for killing an innocent man while on duty feels like a light sentence. The judge extended some officers' protocol to Eric, making a joke out of justice. Eric stood still after hearing the sentence, and after a few moments, he broke down in tears. Well, this officer showed some emotion. Here's a cop who had no remorse throughout his sentence.
Court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000.
Euclid police officer Michael Amion was charged with repeatedly punching a man at a traffic stop. Although Michael claimed he only did it for self-defense, the judge had a different idea.
We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of a misdemeanor of the first degree in violation of section 2903.13A of the Ohio Revised Code as charged in count 2. We do so render our verdict this 29th day of July 2022, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of section 2921.45A.
After 5 days of trial, Michael was found guilty of 1 count of and 1 count of interfering with civil rights.
On behalf of the defendant, do you wish the jury poll?
Yes, Your Honor.
Juror number 1, is this your verdict?
Yes, it is, Your Honor.
Are these your verdicts, I should say?
Yes.
Juror number 2, are these your verdicts?
Yes.
Juror number 3, are these your verdicts?
Yes, Your Honor.
Juror number 4, are these your verdicts?
Yes, Your Honor.
Juror number 5, are these your verdicts?
Yes.
Juror number 6, are these your verdicts? Juror number 7, are these your verdicts?
Yes.
Juror number 8, are these your verdicts?
Yes.
Anything further of the jury? Ladies and gentlemen of the jury, I want to thank you all for performing your civic duty. Your job was not to prove anything or disprove anything. Your job was to determine what was presented to you, determine the facts, apply the law, render a verdict. You did that. You should leave feeling that you've done your job. No second guessing, you've done your job. If someone else didn't, that's not your job. You've done it. With that, you will be discharged. If you'd like to hang around a few minutes and talk with me, I will do that. If you do not, that's entirely understandable. Sometimes the lawyers would like to talk with you to determine how they came across to you, but again, that is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor. After thanking the jury, the judge ended the court proceedings. The next day, Michael, who had sat through the trial with a straight face and no visible emotions, was sentenced.
Based upon the evidence presented and the pre-sentence investigation, the court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Dandion. However, given the length of time involved here, the court will use the as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
That's it, Your Honor.
That's all. Good luck to you, sir.
Thank you.
Michael was given a 90-day sentence, which was eventually discarded, and he was given a clean chit. However, he won't terrorize anybody again, as he was fired from the police force. Next, this officer committed something even more horrible and was rightfully sentenced by the judge.
We, the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Former Fort Worth police officer Aaron Dean fatally shot Gianna Jefferson through her bedroom window while responding to a call about open doors at her home. He was charged with, and here's the footage of moments before his sentencing.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in.
Judge, you're wonderful.
The officer stood firm without expressing grief or remorse as the judge proceeded with the sentence.
Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay. If you hand it, please, to Deputy Nicholson. Mr. Dean. Verdict reads, we, the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict. Juror number one, is this your verdict?
Yes, Your Honor.
Juror number three, is this your verdict?
Yes, Your Honor.
Juror number four, is this your verdict?
Yes, Your Honor.
Juror number six, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict?
Yes, Your Honor.
Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict?
Yes, Your Honor.
Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal review.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law.
The jury ultimately convicted him of manslaughter rather than murder, and he was sentenced to 11 years in prison.
You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on his case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? You may be seated. Thank you very much.
Now, if you thought that cop was corrupt, just wait, as this next sheriff did the unthinkable and paid the price for it.
I feel like I'm being very much bullied into doing something that's not right. And I want this court to know that Todd Pate holds himself responsible for everything that he did.
Police officers often face the heat of justice in courtrooms, and today we will be looking at some of the best moments when corrupt cops were held accountable by some honest judges. We begin with former Breckinridge County Sheriff Todd Pate, who is far from a typical defendant. He is facing charges of assault, second offense DUI, criminal mischief, and leaving the scene of an accident.
This time is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement?
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
Then is it your intention to enter a guilty plea at this time or not, sir?
No. Why am I wasting your time?
4 people were hurt in an accident that Todd allegedly caused while driving a car. Shockingly, he fled the scene. When arrested, his blood alcohol was nearly twice the legal limit.
Why am I wasting your time?
Mr. Chambers, what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
The controversy deepened as he disputes the assault charge, thinking it was added solely because of his role as a sheriff and his decision to reject a plea deal offered by the prosecutor.
Like I'm being very much bullied into doing something that's not right, and I want this court to know that Todd Pate holds himself responsible for everything that he did. It's hard for me to lay down and plead to felony charges that don't apply.
Is it your intention today to enter this guilty plea?
And if I could address...
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
With credit for time previously served, he eventually entered a guilty plea and accepted a sentence of 75 days in county jail. Now, this case was intense, but the next courtroom showdown will leave you questioning everything.
We've got a complaint of you out here holding up profanities.
Okay.
I'm not going to tell you again. You have your ID on you? I don't have
Put your hands right here.
In December of 2018, a YouTuber named Otto the Watchdog held several signs while standing on public land. As cars drove by, many waved and honked in support. What started as a peaceful demonstration was about to take a dramatic turn.
Sheriff's Office dispatch.
Hi, there's some people out here at Interstate 30 and South Elm that have some very offensive signs.
Officer Johnny Clark led the Roy City Police Department's response to Otto's location, as officers from the department were dispatched to the scene.
Where's Johnny with the other one? Should be right over here. Thank you. Yes. Some guy holding up a sign that says shit is f***ed up and stuff or something. Still in office. How are you?
Well, I was doing just fine until just a minute ago.
I've already heard you say a cuss word once. So. What do your other signs say, sir? Sir, what do your other signs say?
What am I doing?
Okay, can I see your other signs?
No, leave my feet away.
Sir, we've got a complaint of you out here holding up profanities.
Okay.
Okay, if you don't let me look at your sign, I'll take you in custody for disorderly conduct.
I'm not being disorderly.
Otto was soon approached by officers who confronted him about his sign. Sergeant Dial was clearly displeased with Otto's firm refusal to consent to search or seize his property despite their demands.
I'm not being disorderly.
Okay. I'm not going to tell you again. All right?
I don't consent to any searches or seizures.
Okay. This is offensive to people that are driving by. And families that are driving by. Yes, it's disorderly conduct.
What's the penal code?
It's disorderly conduct.
Can you read that to me?
It's disorderly conduct.
Okay.
You have your ID on you?
No.
Okay. Now you're filling the ID.
I don't have my
Put your hands right here.
The tension reached a boiling point when the senior officer angrily punched Otto's signs out of his hands. Everyone was shocked by the aggression, even Officer Clark.
Roll over. Since he's failing the ID, take him to jail for disorderly conduct. When we're here answering a complaint and you refuse to identify yourself, that is a crime. When you're displaying these signs and people are calling because it's offensive to them, that is another crime. So yes, you have committed a crime. You committed two.
You didn't warn me.
We don't have to warn you. Ignorance of the law, I asked you politely to see your signs and you said
I
no.
don't consent to any searches or seizures of my property or my person.
I'm not going to take it.
In a powerful act of passive resistance, Otto laid down on the ground, showing that the arrest was unlawful. His message was clear, that he wouldn't resist, but wouldn't comply either.
Is that your cell phone and tripod? If it's not, I'm going to leave it sitting here. If it is, I'm going to take it and put it up so somebody doesn't steal it. But if you want to act this way, I'll leave it sitting here and let somebody steal it.
Why would you do that?
Okay. We don't know whose stuff that is either.
I have a question. What am I being arrested for?
The officer just explained.
Now it's time to ask questions. Oh, yeah, it's the time to ask questions.
You know what?
Nobody even asked me to identify. All he did is ask me if I had ID, and I don't have ID.
Let me explain something to you, young man. We're not holding court on the side of the road with you. Okay?
Well, you're arresting me.
We're not holding court with you.
I just want to know why I have handcuffs.
Any questions you have, you can ask the jail or you can ask the court. You gonna get up?
I can.
Okay. Roll back over and I'll help you up.
I'm not sure if I can do that either. I would like to see your supervisor right now before you assault me any further. I am being assaulted. I have not committed a crime.
When the officer threatened to leave Otto's camera at the scene for anybody to take, he then worsened the situation.
I have not committed a crime.
Get up.
I have not committed a crime. I can't get up. You're hurting me. You are hurting me.
Then get up.
I cannot get
then
up
get
like
up.
This. I can't get up like this.
They lift you up.
I'm trying to get up. Matt, please.
Get up.
Well, assist me up instead of trying to.
We're trying to help you up. Lift you up.
I'm trying to be an ass.
Yes. No, I've seen the game before. Roll up to your knees and they will assist you up.
Roll up to my knees. I'm a fat man.
Okay.
Help me to my knees.
We already have one.
Well, help me again.
Now they'll lift you straight up on your feet. Stand up.
Okay, help me up. I have committed no crime. I have committed no crime whatsoever. Get my equipment.
That's not yours. Remember, I asked you earlier. Come on.
So you're going to leave my shit on the side of the road. My equipment.
Get my equipment. You dude, I'm asking for you to get my. Hey, I've committed no crime. Unlock your car, please. No crime. I want to turn this phone off. I ain't turning nothing off. I'm gonna leave it right like that. Put it in evidence.
According to the Texas Penal Code, people are not required to identify themselves until they are under arrest, despite the officer's claims that Otto was held for failing to identify himself.
I asked him if it was his. He didn't want to talk. I heard it, though. Yeah. He knew where his car was. Somewhere up there. If I had to bet.
Still under arrest for failed ID.
I was under arrest, and then I ID'd, as the code says.
No, the code says when you're legally detained, you're required to ID yourself. You did not.
It specifically says arrested. Okay. I didn't do nothing.
What's your phone number?
I didn't do nothing.
In response to this injustice, Otto sued Officer Short and Sergeant Dial, claiming they had violated his First Amendment rights and engaged in malicious prosecution. Otto's attorney expertly undermined the sergeant's case throughout the deposition, leaving him completely vulnerable and unable to justify his conduct.
As I explained earlier, one, it was an officer safety issue because I don't know what the signs are made out of or what they were. They could be used as a weapon. And secondly, we were still investigating whether a crime had been committed, and he was unwilling to show us what the other two signs or what the sign said other than what we could see.
Did you believe that Mr. Knowles had an obligation to give you those signs?
What do you mean, an obligation?
Did you have the right to see those signs?
Well, it's part of our investigation.
Did Mr. Knowles have the right to refuse showing you the signs?
Anybody can refuse anything. Objection form.
Why did you hit the sign so hard?
Objection form.
Sergeant Dial should have a firm grasp of the law after 11 years on the police force, yet his ignorance was clearly evident throughout the deposition.
I don't know what your definition of hard and soft is, and that was 5 years ago.
How do you define hard and soft? You can use your own definition, please.
In regards to what?
The level of force that you applied to the signs.
I mean, I don't know how I would describe hitting a sign soft or hard.
Why didn't you use less force when touching the signs?
Objection. I didn't know I used too much force.
Could you have used less force when touching the signs?
Objection form. In regards to what? I mean, what was the amount of force that I used?
You said earlier that you conducted an investigation after you arrived on the scene that day with Knowles. What were the results of that investigation?
In regards to what?
In addition to violating Otto's rights under the First, Fourth, and 14th Amendments, Sergeant Dial's utter lack of understanding about disorderly conduct laws was painfully clear.
Did you find anything during your investigation that caused you to arrest Knowles, that caused anyone to arrest Knowles?
Through our investigation, we determined that disorderly conduct had been committed.
How did disorderly conduct get committed?
Due to the verbiage that was on the signs, and we had received complaints.
His ignorance was a clear sign that he was completely unfit for the job.
If you received the same complaints, and those signs had said something different, would Knowles have been arrested?
The same complaints in what? Because the complaint we had was, it was vulgar and offensive.
What I'm asking you is, if the complaints were the same, but the contents of the signs were different, would Knowles have been arrested?
Objection form.
What if the sign said Blue Lives Matter?
How is Blue Lives? There's nothing vulgar about Blue Lives Matter. There's no profanity in Blue Lives Matter.
Are you saying that if the sign said Blue Lives Matter, Knowles would not have been arrested?
I'm telling you that based on the complaints that we received that day, a guy telling me that he was offended by the profanity and vulgar that was being used in the signs.
Objection, non-responsive.
Sergeant Dial said the arrest was initiated because the sign hurt someone, although he could not name any laws that Otto had broken. It is clear he needs to read up on the Constitution before making any more decision.
If the complaints were the same, but the sign said Blue Lives Matter, would Knowles have been arrested that day?
Objection, son. There's no vulgar or profanity in in the verb or term, the verbiage or term Blue Lives Matter.
Do you think anyone that says a bad word publicly should be arrested?
No.
Why not?
Did someone complain on them, or they just out there just throwing a fit? No complaints. I mean, there's several reasons why we would not arrest someone. I mean, if nobody finds it offensive, then disorderly conduct's not met.
So if the language on the signs had not offended someone, Knowles would have been arrested, or would he not have been arrested?
So you're telling me we didn't receive any calls and nobody complained to us? Would we have arrested Knowles that day?
Correct.
No, we wouldn't not have.
During the deposition, the lawyer took over the situation by interrogating Sergeant Dial incessantly. However, the true surprise was still to come.
What specifically did Clark say to you about Knowles' prior disorderly conduct?
He was explaining it to Knowles that as I'm walking up, he's explaining it to him that, look, I've already heard you out here cussing at people.
So he was talking to Knowles, not you?
That is correct.
Did any motorists complain about the prior alleged profanities that Knowles said before you arrived?
Well, the one gentleman told me about the signs, and regarding what the people on 911 called in about, I do not recall that.
If anyone complained about verbal language and you didn't hear any allegedly profane verbal language from Knowles at the scene?
I did not hear it, but I heard Clark explaining to Knowles that he has already witnessed it or observed it himself.
As he prepared to ask the last question, the attorney knew it would leave the officer completely speechless, and it did.
Do you know one word of profanity that Knowles said?
No, I do not.
And you are not aware of any person that was offended by what Knowles said?
No.
When the sergeant unintentionally acknowledged that the arrest was based only on the placard's content, he immediately exposed the constitutional rights infringement and dug his own grave.
Were you offended by the contents of his signs?
No.
Why did you think they were offensive?
The sergeant's errors mounted as the attorney focused on the First Amendment infringement, underscoring his total ignorance of the law.
So you would arrest somebody if a citizen complained about vulgarities?
Objection, Tom. So a citizen made the police department or dispatch aware that they had used profanities and vulgarities and were offended, would I arrest someone?
That's what I'm asking.
Yes.
Have you arrested more than 5 people in your career?
I believe that would be an accurate statement.
Have you observed more than 10 arrests in your career?
I'd probably say I have observed more than 10 arrests in my career.
It is startling that a 10-year police veteran was unaware of the First Amendment. This then calls into question the caliber of law enforcement training. What sort of personnel are we teaching to serve and defend?
Have you observed more than 25?
That I don't know.
Have you observed more than 30 arrests in your career?
I don't know.
Do you remember any specific details about your training regarding First Amendment rights?
No, I do not.
Are you saying that you don't remember one word from your training regarding First Amendment rights?
Objection. That is correct. We went over the elements of the Constitution, and I believe the First Amendment is part of the Constitution.
But specifically the First Amendment, you don't remember?
Correct.
Do you remember how long you spent studying constitutional rights?
No, I do not.
Have you had any training related to constitutional rights since you became an officer?
I do not recall.
It is baffling that someone in such a high-ranking position could exhibit such a glaring lack of knowledge. How can we trust officers with such critical authority when they don't even understand the basics of the Constitution?
What topics have you been trained on since you became an officer?
I don't recall all of them.
Name one.
Accident investigation.
Anything else?
I'm sure there's others.
Where did you receive the training regarding constitutional rights in 2007?
When I was in the police academy, is that what you're referring to?
I'm referring to the training that you referred to, that you received in 2007 regarding First Amendment rights.
The Collin County College Police Academy.
And who trained you in constitutional rights?
Could not tell you.
Because you don't remember?
You're asking for the instructor's name? No, I do not remember the instructor's name.
This is the result of insufficient instruction on the First Amendment and fundamental rights.
Do you remember anything about the protections provided to citizens by the First Amendment?
No, I do not.
Are you aware that the First Amendment gives citizens what's known as the freedom of speech? Have you heard of the freedom of speech?
I have.
What do you think that means?
Interpretations are a dime a dozen, but basically someone can speak freely.
Following the deposition, the city was compelled to settle, and Otto was given $25,000.
First Amendment protect a person from being arrested because of what they say.
Objection form calls for legal conclusion.
Do I answer it?
Answer.
I think at times it may.
Has the police department provided you with any subsequent training on constitutional rights since you've been an active officer?
I do not recall.
Have you received any training, guidance, or instruction regarding First Amendment rights while you've been a police officer?
Objection form.
In the police academy, I know we went over the constitutional rights.
But anything since then?
Next, watch as this cop gets owned in court and sentenced to life behind bars.
Get your hands up. Get your hands up. That's what he's treating. That's how he's treating a stranded citizen.
These are the shocking moments when a corrupt cop was finally taken to the cleaners in the courtroom. Massive kudos to these judges for handing out appropriate sentences for these pigs. Particularly the officer in the last case made a devastating mistake. Make sure to watch until the end as the atrocities of these evil cops are unfolded.
I hereby sentence Mr. Raja to 25 years in the Department of Corrections. That is as a minimum mandatory, which was required that he serve day for day.
In October 2015, musician Corey Jones was waiting on the side of the road for help after his truck broke down. That is when Officer Newman Raha arrived in plain clothes and did the unthinkable.
All this because Corey Jones, undeniably a black man, was on the side of the road waiting for a tow truck. Now, that's not accurate. It's not because Corey Jones was sitting there waiting for a tow truck. It's because that defendant right there chose to refuse to act like any reasonable law enforcement officer approaching a stranded citizen in help. That is why Corey Jones died that evening.
Poor Jones struck 3 times in total and died on the spot. Noman Raja was on undercover operation during the time and didn't even need to arrive there to intimidate the poor victim.
He recklessly created a situation which could only be expected to result in somebody being seriously injured or killed. And all the evidence is going to show 3 things at the end of this trial. It's going to show that that defendant shot and Corey Jones. It's going to show that he at no time acted like a law enforcement officer. And it's going to show that he is guilty as charged of manslaughter and attempted first-degree murder with a firearm.
The attorney was doing a brilliant job and made sure to expose Raj's corrupt face in front of the whole world.
Corey Jones was doing nothing except waiting for help on the side of the road because his SUV broke down. And one of the few people that should have unquestionably been there to assist him on the side of that road did exactly the opposite. Instead of being Corey Jones's saving grace, he was his angel of death.
It was later revealed that Raja never displayed his badge for Corey Jones, who didn't even know by the end that he had been murdered by a police officer who was actually there swearing to protect the public.
The evidence will show that there's no way Corey Jones knew, even at the time that he was running, fleeing from the back of his vehicle, running into the dark, seeking cover, laying there on the ground, dying, breathing his last breath. No way that he knew that the person that actually shot and killed him was a law enforcement officer. But see, unfortunately for Corey Jones, his bad luck was turning much worse. Because unknown to him, that defendant was on duty. See, he was a police officer at that time in Palm Beach Gardens Police Department. He was working a detail, a plainclothes detail, where he was supposed to surveil neighborhoods, looking for car burglars. And if he saw anything, he's supposed to call up marked units to come and take care of the issue.
Stay tuned as things were about to get even worse for the defendant, who is having the worst verbal beating of his life.
He cuts right in front of Corey Jones's SUV as his car. He positions himself diagonally, front end of Corey Jones's vehicle, with their bumpers mere feet apart, in an unmarked van with zero indication whatsoever that he's a law enforcement officer at 3 o'clock in the morning on a Saturday turning to Sunday. That's what he chose to do. He runs around the front of that van and immediately becomes confrontational with Corey Jones.
As the attorney exposed Raja's hideous actions, he stood remorseless, showing no emotions whatsoever.
Now, Corey Jones, he's got an expensive jump. He goes into not the nicest parts of Delray Beach for his job. So he did what any lawful American can do. He purchased a firearm. He didn't even pull out the badge, which was in his wallet, in his back pocket, to show to Corey Jones. Much less put on that vest that said police, or even had his radio or his gun. There's nothing but an overly aggressive and immediately hostile attitude. You hear it for yourselves. You make the decision. You're the judges of the credibility of everybody, including him, because you will hear from him.
Raja later lied, claiming he had identified himself as a cop and that Corey had tried to attack him. However, Corey had dialed a number during the incident, and the call recording proved to be the officer's downfall, clearly showing that he never identified himself as a police officer.
Yeah, I'm good. Really? That's what he's saying. That's not how an officer talks to a citizen at 3 o'clock in the morning on the side of the road. But that's how he spoke to what he saw with Corey Jones on the side of that road. And when Corey Jones laughs and says, yeah, now he starts saying even more hostile. Get your hands up. Get your hands up. That's what he's screaming. That's how he's treating a stranded citizen. Immediately within seconds. That's what he's saying. You know, profane orders being shouted at a time when a guy is sitting with a broken down car.
It is truly terrifying to even imagine the pain he must have felt. He was gunned down by the one who should have helped him fix cars.
Once again, get your effing hands up. Drop. 3 shots. Corey's running away. He's already retreating behind his vehicle. Physical evidence shows 3 shots. He chose to fire out of that gun because of the way that he acted.
The attorney made groundbreaking points, highlighting how Raja showed no regard for the victim, framing the incident as nothing less than an assassination.
He made a decision to shoot first and ask questions later. That was his decision. But see, this isn't the end of the story. Because now Corey Jones is running for his life. He is running for the cover of darkness. He's thrown down the gun already that he had in his hand that was meant to protect him. And you got 10 seconds. Because he didn't stop shooting. No, he kept shooting. But you got 10 seconds. That doesn't sound like a long time. When you sit there, you look at that clock, and you hear those seconds tick away, and you consider that Corey Jones is running for his life after being shot at on the side of the road, that's forever. 10 seconds between the third and the fourth shot.
Also highlights how often police misuse officer safety as a justification, leading to some of the worst atrocities committed in its name.
Finally do what he is supposed to do as a law enforcement officer. But that's not what the evidence is going to show he did. It's going to show his recklessness. This absolute reckless behavior from the start is now changing. Before getting much needed assistance, if he was truly in fear of his life, well, he needs to call the cavalry. 30 seconds. Corey Jones is dead, and it's by the culpable negligence or act of that defendant. And he's going to explain to you, the judge will tell you what culpable negligence means. He's going to say it means a course of conduct showing a reckless disregard for human life or the safety of other persons exposed to its dangerous effects of conscious indifference to the consequences.
Finally, after an emotional and compelling statement from the prosecutor, the jury reached a verdict. Took over 3,000 pages of evidence to prove the officer was in the wrong. The prosecutor's words likely did more damage than any evidence could.
We, the jury, find as follows. As to count 1, we find a defendant guilty of manslaughter while armed with a firearm as charged in the information. As to count 2, we find a defendant guilty of attempted first-degree murder as charged in the information. If you find a defendant guilty of attempted first-degree murder, you must next answer the following questions. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant in discharging the firearm actually caused great bodily harm or death to Corey L. Jones? Yes.
Finally, the moment of truth arrived. Evil killer cop was finally sentenced.
On count 1, I hereby sentence him to 25 years in the Department of Corrections. And on count 2, I hereby sentence Mr. Raja to 25 years in the Department of Corrections. That is as a minimum mandatory, which was required that he serve day for day. Those sentences will run concurrently.
Raja was sentenced to 25 years in prison. He is currently serving his sentence. Additionally, Corey's family filed a lawsuit against City, resulting in a $2 million settlement. This case shows just how easily a police officer can destroy his career and his city. Next, we have another tyrant cop. One wrong decision completely changed the lives of many. On January 18, 2019, Officer Sanchez pulled over Gregory Griffin for a traffic stop. Little did anyone know, soon turned into a tragedy.
Turn off the car.
Wow.
Turn off the car.
Wow.
Sir, turn off the vehicle. Turn off the vehicle, sir. Turn it off. Turn off the car and roll down the window. Open the door. Give me that other unit. Open the window. Open the door.
What's up?
I got a 646. Let me see your hands. Let me see your hands. Hands. Hands on the wheel. Let me see your hands. Let me see your hands.
The female officer was intimidatory and rude from the beginning. Just when things seemed to be a fair bit under control, Griffin made the wrong move.
Hands on the wheel. The car's off. Be advised, the vehicle took off. Thomas in Pennsylvania. Zulu 21 Kilo uniform.
The officer you just saw shooting directly at the fleeing car was Giovanni Crespo, a young Newark police officer who was about to make the biggest mistake of his life. Chase went on for miles in the streets of Newark as the officers couldn't stop the idiot driver. That is when Officer Crespo made a decision that would continue to haunt him for the rest of his life.
It should be under his leg.
Does anybody fires a weapon here?
No, here, not here.
Delta 91 go.
Crespo fired a total of 8 bullets at the car in 3 intervals. He eventually struck the driver, Griffin, killing him on the spot. And one of the bullets also hit the passenger, leaving them critically injured.
Did you shoot? No, I didn't shoot. Who shot? Who shot?
Crespo shot. Crespo shot. No, they shot. Crespo shot, and they're gone. Who's dead? No, he just pulled off on me. Pennsylvania and Thomas is where I pulled him over. No.
Was that a motor vehicle stop or was that a foot chase?
No, motor vehicle stop. I pulled him over.
Okay, who you with?
By myself.
Okay.
Everyone on the scene knew that Crespo made a huge blunder. It was only a matter of time before he was charged for the murder.
The car going down Pennsylvania, it was going way too fast. So
you pulled it over as a 521?
Pulled it over as a traffic stop.
Okay.
Just as a traffic stop. Just because he was going too fast.
Okay.
I got behind him on Pennsylvania and Thomas at the red light. I was waiting for the light to turn green. I thought he was going to pull over right on Pennsylvania. He kept going down Thomas, right on that little curb on Thomas. Pulled over right in front of the church. I got out, told him to turn off the car. He keeps telling me why do I need to turn off the car? So I'm like, turn off the car. So I go over 646, I got a man with a gun. The Delta unit puts up Moss and his partner. So I tell him he's got a gun, so they're like, Val, get him out. I go to open the door doesn't open, so I go in to open it from the inside, and he takes off.
Where's your car?
503, I was driving 503.
All right, let's see your car.
403. Crespo was eventually claimed to have broken the departmental's policies, and he was charged with aggravated manslaughter, aggravated assault, and official misconduct. Case went to trial, and after a lengthy argument, his mother pleaded to the judge for a lighter sentence.
When I died, Giovanni, I made a promise to his mom that Giovanni was going to be the best that he could be. And she wanted me to raise him the right way, and I did my best.
I would just like to apologize for the event that occurred, to the victims, to my family that I put through, everybody that been going through hard times because of this. I took a chance at a job where it's life or death every day. And the thin blue line really is just the line.
Ultimately, Crespo was found guilty and was sentenced to 27 years in prison. Good behavior, he would only be spending 23. Well, that brings us to the end of this video. Today we saw cases where some of the worst cops were given long life sentences. Both of these evil murderers made the worst possible decisions of their lives and ultimately caused their own life to come crashing down. The video does give a sense of relief that there is still some justice, which makes sure to hold these tyrants accountable for the heinous crimes that they committed. If you believe in justice being served, please support us by liking this video. Also, if you enjoyed this video, watch the time this cop made a stunning discovery while searching a killer's home.
Can we get an officer right away, please? My husband just shot himself. Stop! Okay, ma'am.